But it is all lined up.
Okay, let's stand for the pledge.
Absolutely. We should do this every time.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, liberty and the public free.
Thank you.
Okay, we're going to call this meeting to order. First we're going to do is attendance. Dave Ott. Here. Becca and Jose.
Present.
Lynn Smith.
Present.
John Elkins.
Here.
Andrew Emmerich. Present. Bill Simonelli here. Todd Reinhardt is not able to make the meeting. I believe we have a quorum. Also, we have with us Chuck Keel, General Manager, and our guest tonight is Rob Case, Association Attorney. Before we get into the main part of the agenda, first of all, I'd just like to thank everybody for coming. The Florida legislature has made some significant additions to the regulations overseeing HOAs. By my count, there's about 39 plus distinct changes that have been made that we'll be going through tonight. And the purpose of this meeting is that we're going to review those changes as a board and with advice from counsel, work through our compliance plan for each one of those. I think some of the changes that they required, especially in the areas of financial transparency, I think our association has a very good track record with already. Some of it is some qualifications or some finer refinements on how the covenants process will work. But I think overall, I haven't seen anything other than probably a lot of work we'll have to do on our website to make sure that we're in compliance with that. So the main structure of the agenda tonight is we'll ask Rob to give us a few opening comments about the legislation and sort of overview at 10,000 feet. And then we're going to jump right into each line item regarding it. And this is going to be primarily for the board to go through a working session. And at the end of the meeting, we will have open Q&A like we normally do, because I thought that after listening to all this, it might stimulate more questions than in the beginning of the meeting. So with that, I'll turn it over to Rob.
Thanks, Bill. So just for the general comment, I think we're going to go through some specific issues as we talk about the list of, action items for the association. This was a very active legislative session for community associations, both condominiums and homeowners association. The amendments to Chapter 720, which is the Homeowners Association Act this year, were probably the most substantive, frankly, since 2000, when they broke Chapter 720 into its own freestanding statute chapter, as opposed to being a subchapter of Chapter 617. So they've done changes throughout the statute. The main bill, which was HB 1203, I believe.
1203, yeah.
Yeah, was converted into the laws of Florida. That's Chapter 2024-221. That's the official laws of Florida designation. Shortly, I imagine in the next month or two, the online statutes, if you use those through the Florida Senate's website, will be updated incorporating these changes, but they are effective today. Some of them have future enactment dates, but generally speaking, the statute's effective today. And it addresses, a number of areas. I think probably most substantively for many associations is how it addresses official records, website requirements, access to records, and then how to do fining and notices of fining, things like that. A number of other substantive changes that were enacted. Also, we'll talk about the hurricane protection provision, requiring the association to have standards for hurricane protection. So I think on the one hand, there's probably work to be done for the association to procedurally react to and comply with the statute. Some of it, you may be things you're already doing, depending on what's already on your website. Now you may need to just update and make sure the records available on your website are comprehensive and comply with the statute, things like that. And there are some other procedural things the association will have to do. For example, by October 1st, the association is obligated to send out copies of its documents and rules, or send out where they can be located online, notice to the owners, things like that. So I think while there's a lot here, I think for many associations, Sandoval included, it's probably not going to be a lot of changes in any day-to-day, affect anyone's lifestyle or the operations of the association. The association has more procedural issues to comply with, different standards to comply with respect to records and things like that. But at the end of the day, I don't know that these changes, although they are significant, really going to have a major impact on how your association operates, where your association is generally operating, as it should be. A lot of these changes are reactionary by the legislature to some bad conduct by certain homeowners associations and condominium associations, mainly on the East Coast, frankly. So we will work with them. We'll deal with the changes. We'll update your policies and procedure to comply with the changes, and react to it as appropriate. So I guess with that,
Okay.
where you want to.
Thank you. We'll start with number one. So procedurally, what we have right now is a breakdown of all the major elements of the rules changes. And we're going to go through each one at a time, give the board members a chance if they have any questions on a particular item to be able to have a discussion with Rob. And then we're going to sort of agree on what our compliance plan is going to be to achieve compliance with that particular requirement. This document that I have up on the screen, this will be published with the minutes, and my goal is that on an ongoing basis at our monthly meetings, at least through the end of this year, we will provide a short update to the community on our efforts to achieve complete compliance with these records. Just keep everybody in the loop on what's going on. So hope this doesn't look like too much of an eye chart to everybody in the audience tonight, but this will be published with the minutes that everybody will have a copy of. Okay, and with that, we'll start with number one. This is a change to, this was HB 293, hurricane protection in HOAs. The board or architectural or similar committee must adopt hurricane protection specifications for each structure or other improvement on any parcel governed by the association. May include color and style, as well as any other factor deemed relevant by the board or committee. All specifications must comply with applicable building codes. Okay. Does any board members have a question on this?
I do.
Go ahead, Bethany.
So looking back at this, does that mean that the HOA could now be more specific in regards to what colors are allowed in each section, rather than looking shades up? Could that give us the ability to do that?
Well, I don't think this changed that. I mean,
Okay.
the associate, what this entire new provision really operates to do is to say the association must adopt whatever hurricane protection specifications it wants, and it must allow owners to install that. I think the net effect of this is if you don't adopt this, if you don't adopt guidelines on we'll use shutters, for example, although it's broader than shutters. If you don't adopt guidelines that says these are the shutters we allow, these 3 styles, and they have to be the same trim color as your house, whatever. That's an appropriate rule that any owner knows. If I put in an application for a allowable style and an allowable color, it'll have to be approved. If you don't have that rule, say you have no shutter rule, my opinion is an owner can say, well, I get to install code compliant protection. So I get to put up, unpainted corrugated metal shutters that are not, the same color as my house, because you have not adopted the rule that says these are the shutters you can have and these are its specs. So the color should be specific. If you have a color palette for a neighborhood, that say, houses have to be these colors with these trims. The rule should be you could have these style of shutters. They can be, whatever, accordion, panels, roll down, but they have to be, compliant, and they have to be these color palettes, white or the trim of your house, whatever you want it to be.
Right.
But you should be specific. And if you're specific, this statute gives you the authority to adopt those rules and enforce those rules. And it also gives the owners the understanding that if they apply to put up shutters that comply with those rules, that must be allowed.
Okay.
And I use shutter as an example, but hurricane protection is broader than that. That's impact glass windows and doors, that flood barricades, that roof systems can be that. So it doesn't mean you have to change what your roof style, color, etc. is allowed. It just says if these are your standards, these are your guidelines, they have to be permitted when they're released.
And probably more appropriate for later on, but I'll ask it now. And I think you just answered it, but I want to make sure we have clarification. Currently, we have timeframes where shutters can go up and then be taken down. When we look at, all the rules that are applicable, the garage, garbage, parking, is that something that the board has to be specific about? But I think you just answered it, Rob. I think it really doesn't have to do with what's in here, but
Correct.
more what the board is going to require under their rules.
Right.
Okay.
So this statute doesn't get to rules regarding deployment, 72 hours before storm, week
Okay.
after, whatever. That's not addressed here.
Okay, I just want to make sure that if we do that, then we will still be in compliance with what the legislation.
Yeah, this statute doesn't speak to that.
Okay, all right.
All right, so my suggestion is that for line item 1, that this be assigned to the ARC to review and prepare any modifications to the design standards that this statute requires. Does that sound reasonable to everybody?
I would like Art to make the language and rules to review it before presentation to the board.
Yes. Say that again, Andrew.
Art will create the language, rules will review the language before presenting to the board for approval or consultation further with council.
Sure. Review and approval by board. How's that?
Yep.
Okay. Oops. Everybody sees how good of a typist I am. Okay, next one. Notwithstanding anything in the governing documents, an association may not deny an application for the installation, enhancement, or replacement of hurricane protection which conforms to the specifications adopted. The association may require the owner to adhere to existing unified building scheme for external appearance of structure and other improvements. Is there any questions on this line item? I think this also should be assigned to the ARC. Are we agreed with that? Okay. Third line item, hurricane protection includes, but is not limited to roof systems under Florida Building Code that meets ASCE 7-22 standards, permanent fixed storm shutters, roll down track storm shutters, impact resistant windows and doors, polycarbonate panels, reinforced garage doors, erosion controls, exterior fixed generators, fuel storage tanks, and other hurricane protect products used to preserve and protect structures and improvements. Any questions on this one?
Can you hear me?
Yes.
Only question I have is fuel storage tanks. Right now, we're pretty well bound by Cape Coral Code, are we not?
Yes, and there are some rules in our design guidelines that specify the distance from the structure.
Yeah, particularly like if you have a generator, you have a buried tank of 500 plus gallons.
Yeah.
Within so many feet. That's already in our rules, is it not?
Yes. I know there's an open arc application that I sat through that.
So that's consistent with this. Yes. Okay.
Just need to make sure that our language is consistent with the intent of this requirement.
Correct.
Okay. This is where we get into the fun part. Okay.
I think all three of those are, they're really.
Yeah, yes. Okay.
Rules reviewing that.
Okay.
Board approving.
All right. So this is where we get into a lot of the transparency requirements. This section is required is created to acquire HOAs prior to October 1st, 2024 to provide a physical or digital copy of the association rules and governing documents to all members. New section may be satisfied by posting complete set of rules and covenants or a link to them on the homepage of the association's website. If the site is accessible to the members and the association sends notice to all members that it will use the website for this purpose. Notice may be sent electronically to those that have previously consented or physical mail to the address the association has on file. So I think we are partially in compliance with this today. We have our governing documents on the website. I do not believe we have this opt-in structure in place, Chuck.
Yeah,
We do have it.
for Live Sandoval.
No, but if someone, do we have a definitive list of who to send out a physical copy to?
Oh, yes.
We do. Okay. All right. Do we have any other questions on this?
So I just want to make sure that this does not require physical mailing. It's either or, right? Because a physical mailing costs us about $14,000. Is that right? Somewhere in there.
Mailed out your entire documents?
Yeah.
Oh, well, no. I mean, just a.
Your governing document.
Oh,
So you can. There's copy announced to.
yeah. I thought you would.
If you have either electronically send out a notice by email to owners who have consented to receive official notice from the association by email, or to those who have not, send out by regular mail a notice that says all of our governing documents can be found at this website, www.sandovaldocuments.com. You probably have them all there now.
Right.
Yes, sir.
So you just have to send out a notice to everyone saying, here's where the documents can be found. And you have to send out that notice by October 1st, 2024. So that's something I think that can be procedurally handled pretty easily.
Would we have to do that to governing docs and then also a link specifically to architectural related?
And rule and
Okay, so if it's multiple links, we got to specifically give the link, just cannot give the website.
Let me finish my question. If a resident wants all the governing documents, is it reasonable and legal to say they're available here electronically rather than have to print the whole thing?
well, this new law does not require you to print and mail them. If an owner says, I want a hard copy of the governing documents, the association is obligated to make a copy and provide it to them at their expense. So that's a records inspection issue. This doesn't say that.
Okay.
At their expense, because they're copying a record. This is not contemplated here, but the other thing you can do to that owner, if it's available, you say, you can provide them by email, by PDF, if they want it that way. Same as downloading it from the website. But this doesn't create the obligation to print and give it to someone separate from their right to request that as a record.
Right. But I just want to make sure, one point I just want to make sure I'm clear on is that, does this require us by October 1st to send out a notice of availability to all the residents?
Yes, that's what you're required.
Okay, so notice of availability has to be sent out.
And it must include the specific links.
Yep.
With specific links.
And we can work with you on that. We'll also have.
Yes, so we'll work with council on text. Okay.
Bill, I know.
Okay, let me just, I don't type fast, sorry. Yeah, everybody's gonna be painful watching me type. Okay, yes, Becky.
Go left. email addresses so that when homeowners move out of the community, because some of that information that's on the website is confidential to homeowners.
Yes.
So who will maintain that list of who should get it and who should not get it?
My understanding, and I'm looking to Chuck, that is the responsibility of the management company to maintain the accuracy of that list. Do you agree with that, Chuck? Okay. To answer your question? Okay. Good. Now, which committee is going to oversee seeing this get out?
I think that should just be the board. I don't know that.
Okay. Okay. This will be overseen by board. Okay.
Because again, it's just going to be a notice. I mean, it's not to really know.
Okay.
Well, other than ensuring everything's on the website.
Okay. All right. Now, this one is all new members must receive a copy of the rules and covenants. Okay. So I know in the past, there has been a practice to give new members, new owners, a welcome package that includes a list of information. So I think we need to revive that procedure specifically so that it includes this notice of where to get the information. Also, I know that the Communications Committee is working on creating or updating the real estate page on the public side of the website so that so a lot of that information is more readily accessible to the realtors and potential buyers so they can view that prior to offers or during the transaction process.
Can we include that in the owner's handbook?
Include what, John?
This
Notice.
This notice, yeah.
Yes. Okay.
Right.
Okay. Include owner's handbook. Sorry. Okay. So we'll do this. This will be a board.
If it's on our website.
Okay. Board ownership. That's good. Okay. If amended, new copies must be provided to all members. Association may adopt rules for the distribution and time frame for providing copies of updated documents. So to me, this is, do we have any questions on this before I give my comments on it? Okay, so this is a two for one is we need to have the rules committee define the practice in place for how we're going to notify members of rule changes so that we're in compliance with this. Okay.
Rob, is that a thing that needs to be done every rule change, or is that something that can be announced once a year?
I think it has to be done with every rule check.
Okay.
And again, you can comply with that notice requirement by sending out a notice by email or mail to those people that don't know the email. It just says the rules have been amended and they're available at the website.
Understood.
So you don't have to send out another.
Right.
You always comply by just sending out a notice saying, this is what we did, and here's where they're.
And here are the links again.
Yeah. Yes.
Okay.
So the second half of the twofer is that I would recommend that the Rules Committee needs to work in conjunction with the Communications Committee for how to, what the links are and see if we can streamline the access on the webpage to this particular section of information. Okay.
Well, that's it. Yeah. Anytime we do these mailings, you're not going to just let the affidavit in the mail. So you get it.
Okay. All right. This does not impact the association, it impacts CAMs. They must attend in person at least one member board meeting annually. I think Chuck, our and past management companies have been present at all board meetings and association meetings, so I think we're good there. Provide the members of the community with the names and contact information of the CAM or representative of the firm assigned to that community, their hours of availability, and a summary of duties for which they are responsible. I believe that is currently on our website. Live Sandoval. The HOA shall also post this information on the association website application. The CAM/firm must update the information with 14 days after change to any of this information. Provide any member upon request a copy of the contract between the HOA and the CAM management firm and include the contract in the official records of the community. We'll get into contract disclosure in a few minutes, but I believe that we're pretty much in compliance with what's on available Live Sandoval today. I just would ask that Associa and Communications Committee take a quick look to make sure that there's nothing else that needs to be added to be in compliance with this. Okay. Continuing education. CAM who works with an HOA must complete at least 5 hours of continuing education specific to HOAs, 3 hours of which must be related to record keeping. Pardon me? What'd you say, John?
And is it 10?
Cannot be required to have more than 10 hours annual for review.
Oh, okay. Got it.
So one of the things that I understand is there's a later requirement that that we need to document your ongoing continuing education for the CAM or any subsequent CAMs. So this is going to be something we're going to have to put on the Live Sandoval site where this information can be made available to the community. Oops. Okay. Next one. Official records must be maintained longer than 7 years if a longer duration is stated in the governing documents. As far as I know, we're only required for 7 years. I haven't seen any.
Yeah. I don't know that I've ever seen a document,
Okay.
some documents that address the duration of record retention. So,
Okay. So, Chuck, could you just give everybody a quick update on what you're doing with the digital archiving at this point?
Yes, the majority of, when they did the renovation of the clubhouse, everything was in filing cabinets. Those filing cabinets were emptied and put into boxes. The boxes were sent off-site for storage. We've retrieved those boxes and we're in the process now of going through every single box and documenting what is in that box and how exactly what's in that box, and how long we need to keep that box. It's then put onto a system called Vital Records, which is a company that we've contracted to take those documents and put them in a air-conditioned, water-safe, basically a vault that fireproof and all that other good stuff. Instead of the $60 a month stored right across the street on Pine Island. Which had us concerned during the hurricane that if it got flooded, we would lose some records there. So we have a temp, as you know, was budgeted last year, and she's here on site, going through boxes, scanning documents. Happy to say that we've gone through. I think we've gone all the way back to the beginning of time with minutes. For better or for worse, some of these minutes were. Contain not only the minutes, but the general manager's notes. So we're painstakingly going through everything and making sure we digitize the minutes, and so we have those electronically, as well as having them secured in a facility that is more appropriate for this level of documents. So,
okay. Any other questions from the board members? Okay. So I think we just need to see this digital archiving process completed. Let's stay on top of that. Okay. Next one, and this is where we're seeing a lot of significant requirements. By January 1st, 2025, all HOAs with 100 or more parcels, of which we are, shall post the following documents on its website or make them available through an application that can be downloaded on a mobile device. Declaration, articles of incorporation, bylaws, and the rules and regulations of the association. A list of all current executory contracts or documents to which the association is a party to or under which the association or owners have an obligation or responsibility. And after bidding for related materials, equipment, or services, has closed a list of bids received within the past year. Annual budget and any proposed budget to be considered at the annual meeting. Financial reports and monthly income and expense statements to be considered at a meeting. All current insurance policies. Certification for each director as required under Section 720-30331A. All contracts or transactions between association and any director, officer, corporation, firm, or association that is not an affiliated HOA or any other entity in which a director is also a director of or officer and has a financial interest. Any contract or document regarding a conflict of interest or possible conflict of interest. Okay, so let's start at the beginning. First of all, do any board members have questions on this? Okay. I believe we are in compliance with the declaration, articles of incorporation, bylaws, and rules and regulations. We do not have a list of all our current executory contracts or bids received related. That is something that will have to be added to our Live Sandoval site in some form or manner. The annual budget and any proposed budget to be considered, I believe, at least for the last several years, has been part of the Sandoval site. I do not believe we have a copy of the insurance policies on the site, so that has to be added. The certification for each director required under Section 720-3033. I know that the secretary and the general manager have been keeping those records, but we now have to add those to Live Sandoval. We do not have contracts or transactions between the association and any director, officer, so on and so forth. So we'll have to build a section for that too. Any contract or document regarding a conflict of interest or possible conflict of interest. All the board members had to sign a code of ethics statement where they put in any information related to a possible conflict of interest, and I think those will have to be added to the website too. Okay.
I have a question.
Shoot, John.
The all contracts and all bids have to be placed on the website and available to all members.
Well, what provides for a list of list of all things. So it doesn't require that you have all the contract documents
Okay.
on the website. Just this time would require a list.
Some bids are sealed. Some bids. If this becomes, for instance, this would highlight or heighten the need for security on our website.
Yes, it would say that this, list all contracts, or contract, and I'm being going through the list of bids, which is not here in the last. So yeah, this price and a list of bids.
Not the details. No.
It doesn't tell the detail. Now, that regulate a question.
Yeah.
So we wrote the contract and bid documents are official records, so these will say available for whether or not to move those. And the other one, shopping this, making the room bills to the room. I remember the perfect that is not acceptable. And we have to decide on one, who you think your website publish. So your point, the very point, these all documents are house. Behind the rock, and you want to, be, um. On the conflict of interest, just I want to note that it references two different statutes for conflict of interest. Director conflicts of interest. What the statute says is the association is not prohibited from entering into a contract with a director or a entity that the director has a financial interest in. There are procedural hoops the association must jump through regarding disclosure and approval of such a contract, but they are not prohibited by the statute. If you go through those hoops to enter into a conflicted agreement with a director, it's still permitted, but again, there are requirements you have to go through, and the members have the right to terminate that agreement at the next membership meeting following its execution. I'm not aware that the association has entered into any such agreement. I don't think any board member has a landscaping company or a painting company that you're working with, but that's what that's getting to. With respect to the other conflict of interest in 486, that is when the management company has a conflict because they have an affiliated service provider that they have brought to the association to provide a service. And there are specific and different bidding requirements in that situation. And while they're considered a conflict of interest, it's not in the sense that it's inappropriate. It's just, it's subject to greater scrutiny. And it's subject to the provision that you have to disclose that contract. Separate from your management company contract, it's their affiliated entity contract. That one isn't just listed, it has to be displayed, the text of it. So again, I don't know that you have any contracts that fit that definition, but those are the two types of contracts they're talking.
Would banking relationships fall into that category?
Well, in theory, if we did business with a bank that a board member was an employee of, it's in theory would be, I think, would fall into that category, but we don't have any relationships like that today.
The conflict of interest language, right now, that's like if you're the truist, if someone is a loan officer or truist, that's not the type of conflict.
Okay.
That doesn't rise to the level of conflict.
Okay.
If they were the CEO, maybe different.
Okay.
So that's how I would do that. They have a specific financial interest in that entity or a family member.
Bethany, you have a question?
That applies to a realtor?
The association has a contract with the realtor,
No, if somebody on the board is a realtor.
and the association has a contract with them. This is about association contracts. So if you're a realtor and you sell houses in Sandoval, the association doesn't have a contract with you. The association is not paying you money.
Okay.
So that's not a conflict of interest that would require disclosure.
What about with the homeowner? So if the association hires a homeowner,
They're not a director.
that's okay.
Okay.
All right.
Good.
I'm not a fan of the association doing business with directors or owners for a variety of reasons,
I agree.
but that's not a required conflict disclosure if they're not a director.
Okay. Any other questions on this? So I'll go in and add the line item specifically that needed to be added to Live Sandoval that we have to look at, and then this will be something that we'll have to take on at the communications committee. And one of the other things is that we will bring up for formal consideration the level of documentation we want the communications committee to put on the website relative to contracts. We'll have a specific discussion about that at a subsequent board meeting. Okay. Okay. This has been causing some confusion for me. On January 1st, 2025, all HOAs with 100 or more parcels shall post the following documents on its website and make them available through an application that can be downloaded on a mobile device. Notice and agenda of any scheduled members' meeting. The notice must be placed 14 days prior to the meeting and be posted in plain view on the homepage or on a separate subpage labeled notices, which must be conspicuously and visible and linked from the homepage. Must also post any documents to be voted on or any document listed in the agenda at least 7 days before the meeting. Notice and agenda of any scheduled board meetings and any other documents to be voted on or listed in the agenda no later than the date required for notice under subsection 3, 48 hours or 14 days, depending on subject. So, Rob, you and I had some correspondence on this, and my understanding from our correspondence is that the 14-day notice relates to the annual meeting and not board meetings.
Right, that's meetings of the members. So typically that's the annual meeting, but if you call it a special membership meeting to vote on an amendment to the documents, that requires 14 days notice. So this does not change any of your notice requirements timelines. They're still 14 days or 48 hours
Right.
last 14 days, 14 days for membership meetings, 14 or 48 hours for board meetings, depending on the subject of the board meeting. Certain board meetings require 14 days notice, assessments, rules regarding parcel use.
And we have some notice requirements relative to the budget and stuff like that too.
Under your document.
Right, so we have to follow it.
So this just is adding basically the timelines are the same. You just have another way you have to provide it. You have to mail it or email it, and now you got to put it on the website.
Right. So this does put a requirement on Live Sandoval that we have to do a notices section. Yeah, so, okay. Update to Live Sandoval. So this will be a communications committee requirement. Okay. All right. Any other questions on this one from the board members before we move on? Okay. Website application must be accessible through the internet and contain a subpage, portal, or other protected electronic location that is inaccessible to the general public and accessible only to parcel owners and employees of the association. Do we have any questions on that? Because I believe we are in compliance with that today.
Maybe, but what is a substate order?
So if you look at our website today, before you log in, you go to a main page, and then there's a member login, and that takes you to the behind the firewall or the protected site that only you have access to as a member. Okay, so that's a subpage portal. Okay. Now, if we really wanted to make our life difficult, we'd do two-factor authentication. No. I have enough problems just checking my bank balances. Okay. Upon written request by a member, the association must provide them with a username and password, as well as access to the protected sections of the website that contain official documents of the association. I believe that we are in compliance with that today. Do you have any questions on that? Rob, you got a comment?
No, well, it boggles the mind on what set of facts occurred, and I'm sure they happened, that the legislature felt that was necessary to legislate that you have to give people their password when they ask for it. Well, again, there's some bad behavior out there.
Yeah.
You know, obviously, you do that, and we'll do that.
Yeah. Okay, next one. Are we having fun? The HOA must ensure the information and records are not accessible and are not posted on the website application. If protected information is included on documents that the HOA must post on the website application, It must ensure the information is redacted before posting the documents. Association is not liable for failing in its duty unless the disclosure was made knowingly or with intentional disregard of the protected information. As far as, pardon me?
Do we have anything that applies here?
Well, for example, some associations may put their compliance packages that we see privately on the website, so that would.
Oh.
So, but as far as I know, we do not put any confidential information
I don't think we do.
on Life Sandoval, and I know that there's an additional level of protection for the board to have access to information on Town Square to more detailed information on the financial side that the community does not have. I don't think, Rob, I don't think I'm missing anything here on this one.
This would really apply kind of to the example you gave, if you were posting more of your records than the statute's requiring. Like, for example, if you were posting all of the ARC applications, and say you got an ARC application with medical information because the person wanted to put a ramp in, and they have a letter from their doctor. That letter might be the type of thing that you should redact because it's health information that shouldn't be disclosed.
Okay.
Similarly,
I never thought of that.
confidential, privileged communications from your law firm are not subject to disclosure, so they shouldn't be on the website. Employee and personnel records. So while the management company contract is a record, and the impact on the budget for any, employees or leased employees are proper records. If you had, disciplinary files or, their W-2 and stuff like that, those are exempt, so they shouldn't be on the website. The statute lists all the exempted records, records you obtain in connection with approval of sales or leases. You do not disclose. That would not be on there. If you got a copy of someone's driver's license for some reason, that wouldn't be on there. So I think the routine documents we've been talking about don't really implicate this, but I would tell the board and the communications committee, if as you're updating your documents and getting more voluminous in what you put online, because I think it is in the association's interest broadly to digitize and post as many records as you can, because one, it makes them more accessible to the members, and it makes, I think, the board and the management company's life easier with making records available when you're required. But when you start adding these additional layers of records, that you have a critical eye on what you're posting, and not post something if there's a question until you can resolve.
Okay. All right. I'm not quite sure if there's any more action we need to do on this one other than to follow current processes. Any comments from our board members on this?
I think we'll go the way we are.
Okay.
so.
Okay. 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 HOA must adopt written rules governing the method or policy for official records to be retained and time period such records must be retained. The information must be made available to members through the website application. This is going to have to be a business practice decided on by the board. Rob, do you have any comments on this one?
The only comment I was going to make, and we're going to talk about records accessed by owners because there's some changes there. I think the board, we should work on like a comprehensive records rule that addresses retention and also member access and inspection and copying and disclosure of records just broadly. But I think this is something that, if you have to adopt a rule, I don't think it has to be overly complicated. Some of it's dictated by law. Some records you got to keep forever. Some records you got to keep for 7 years. Some records you got to keep for 1 year or until the next annual meeting. So, some of that is pretty straightforward. But I think you want to combine this with maybe a more encompassing record rule on owner inspection rights and how records are going to be disclosed, what records are going to be put on the website, that sort of thing.
Okay. Okay. I think this is something we should assign to the Rules Committee to put together. Andrew, your thoughts on that?
Business practices?
Yeah.
Okay. Or are we working with council on this?
Yes, yes, you can work with the council on that.
Okay.
Yes. Okay. All right. All right. Next one. Any director or CAM who knowingly, willfully, and repeatedly violates a member's rights to inspect records with the intention of causing harm to association or its members commits a second-degree misdemeanor. Repeatedly means 2 or more times within a 12-month period. Any questions on that?
I do appreciate that the legislature did not list attorneys there.
I think attorneys got carved out in another one, if I'm not mistaken, Rob.
No, look, I don't think this is really an action item. You know, records must be made available.
Right.
As I said before, we're going to work on a policy on how member rights to records are effectuated to make it easy on the board and management and the members. But again, there are serious consequences to failing to make records available.
Right. Okay. So the next two lines, 16 and 17, I think fall into the same category, which is we understand the rules we have our obligations to provide information when requested. Any other questions or comments on that? Yeah, John.
Not directly related. That is, when we have a session for new residents, we should probably include some sort of training then in how to use Live Sandoval and access these things and make that available, maybe even on a video for all members. Because some people might have trouble doing this access. Maybe we need to have a little class or something on how to do it.
Yeah, I suspect, I mean, I don't want to speak for the communications committee, but I suspect with all the changes, there's going to be like a formal launch of the new Live Sandoval or the new and improved Live Sandoval. That would be a good time to do sort of like a training session, training video, maybe even have an open town hall to introduce the residents to the new version. Okay. So I'm just going to skip to 18. If the HOA receives a subpoena for records from a law enforcement agency, it must provide a copy of the records or make them available for inspection and copying within 5 business days unless otherwise specified in the subpoena or by the agency. An association must assist a law enforcement agency with its investigation to the extent possible by law. So I don't understand it to be a change to what we've had to do today, Rob. I'm curious why that was there in the first place.
We get more time for it.
I don't know.
Well, I mean, it said unless otherwise specified by the subpoena. I've only dealt with a number of third-party records corrections. Those were in the context of civil litigation between third parties, owners and their insurance company, owners and someone else. And there, the association is a non-party to that lawsuit. But if you get served with a subpoena in a civil case like that, you have to comply or object or deal with it. This is talking about law enforcement subpoenas. I don't know that you've ever gotten one of those, to be honest. Like, I don't know that FDLE or the sheriff's department served you with a subpoena that says gives us records. I mean, this is not
that I'm aware of.
These are not civil actions. This is,
Right.
I don't know what an association must assist a law enforcement agency with its investigation to the extent possible by law means. I also question if that's legal in the sense of they can't compel you to do that. I think I have two minds of this provision. I think it's very problematic,
Mm-hmm.
and I think it probably will never be an issue.
Okay. All right.
But if the sheriff or the FBI shows up at your door, y'all have talked to Kevin Miller in the past. Just call him directly.
Okay.
Don't call me.
We'll have him on speed dial. Yeah. For Kevin Miller is an associate at Rob's law firm that has worked with us on information requests for potential civil litigation in the last couple of months. So,
Yeah, he's my litigation partner.
Yeah.
I just give him the problems.
yeah. Okay. All right. An HOA with at least 1,000 parcels must prepare audited financial statements, notwithstanding its total annual revenue. We have been doing audited statements, as far as I know, for many years, so I believe we're in compliance with this requirement.
This doesn't apply to you because there's a different provision that talks about financial statements that tiers it based on revenue.
Okay.
And if you have revenue of more than $500,000, you have to get an audit. You have revenue in excess of $500,000. You have an audit obligation anyway.
Mm-hmm.
This is for, I think there are a few homeowners associations throughout the state that this was geared towards that have very low assessment,
Mm-hmm.
very large basis, so they didn't have that $500,000 cap because like their assessments were $250 a year, but they have 1,500 lots, so they're less than 500,000, so they're not getting audits. So that's what this geared for. This doesn't apply to you because you have to get an audit anyway. The next section does apply to you to the extent you ever wanted to vote to waive your audit requirement.
Okay. Okay. This is current. Okay. This, I think we just understood. I mean, our practice is to do an audit, review it with the board and have the board vote on it. And I believe the last several years audits are already on Live Sandoval for community inspection.
Yeah. So how this provides is what the statute says is if you have revenues in excess of $500,000, you must have if you have revenues between $300 and $499, you have to have reviewed financial statements. 150 or 100, I can't remember which, to 299, you have a compilation. Less than that, you have cash receipts and expenditures. Those are the 4 required financial standards based on your revenue.
Mm-hmm.
When you have the audit level obligation, prior to this amendment, the members could vote annually to waive the audit requirement to something less. So you could vote to waive the audit down to a review, waive the audit down to a compilation, waive the audit down to cash receipts and expenditures. And there was no limit on how many times you could waive in a row. So theoretically, you could have $1 million in revenue annually and never have an audit because every year the members vote to waive the audit. This just says you can vote to waive the audit this year, but then you got to get it next year and on and on. If you don't waive your audit routinely, and I don't think you do, this applies to you, but probably doesn't affect you because you were getting audits anyway. That's how that works. It does apply, but it's probably not a material issue because you're doing your audit.
We're doing audits as a standard practice every year.
But you could skip a year now and do it next year if you wanted to. That's a membership vote, has to be taken at a membership meeting, has to be taken before the end of the fiscal year in question. So if your annual meeting is March or April, right?
Like second week in March.
Right. So you couldn't vote in March of 2025 to waive the audit for 2024. You're too late. You'd have to do it in 2025 for 2025. I'm not suggesting you do that. That's just how you.
Okay.
Does that apply to condos as well? 718?
Yes, they included that you can't do it you can only do it every other year. Used to be in several years ago, maybe 2012 in condo, they had like a weird 3-year rolling deadline. Then they repealed that. You could waive as much as you wanted. Now it's every other. For condo, that's not.
All right. Okay. Okay. Any other questions or comments on that one before we move on? Okay. Next one, debit cards used for any expense that is not a lawful obligation of the association commits theft and must be removed from office. Lawful obligation means any obligation that has been properly pre-approved by the board and reflected in meeting minutes or written budget. I believe this applies to directors.
Yeah, so there's two things here.
Yeah.
I mean, one, you're not supposed to use debit cards, period.
Okay.
So if you use a debit card for a proper common expense, that doesn't trigger the next thing we're going to talk about, but you're just not supposed to use debit cards. That's just the predicate. But if you use a debit card for an expense that is not a lawful obligation of the association, proper common expense, then that director is subject to penalty and can be removed from the board. So the takeaway here is I don't know if you use debit cards in the name of the association.
We do not have, as far as I know, the only credit account we have is with Home Depot. Chuck?
Yeah.
Correct. It's a credit account. It's not a debit account.
Credit card, this is not subject to. It's just debit.
So let me give you a what if. So what if we're doing a social event and a director uses their personal debit card to purchase some supplies for that event
That's fine.
for reimbursement?
And the board has a reimbursement policy, and that's fine because their debit card is not in the association's name. It's in the name of the association,
Okay.
which makes some sense. I think it's a bad idea to have a debit card linked to the association's bank account.
Yeah.
You know, credit cards are safer. You know, whether or not you want a credit card's a different question. But just don't have a debit card, you're fine.
Right. So from a financial practices, we just have that one credit card account or credit account with Home Depot, correct, Chuck? And we have no other credit cards, official credit cards with the association. Okay. All right. Okay, the next one. A member who makes a written request for a detailed accounting for their account, what they owe, must receive such information within 15 business days of receipt of the request. The member may not make another request for 90 calendar days. Failure to respond within 15 business days constitutes a waiver of any outstanding fines which are more than 30 days past due or for which the association has not given prior written notice of the imposition of fines. Questions on this one?
I have questions, but
Yeah, go ahead,
I
Rob.
don't know what it means or what its intent is. There's a whole different provision that deals with a estoppel certificate.
Right.
This is an example of, and this happens in the HOA Act with some frequency, where some legislator, or more likely their parent, got into a fight with their HOA over some very specific, discrete set of facts. And they got mad and they got this into the bill. This has happened before. There's a provision about lots cannot have two fronts if they're a corner. And that's because of a fight in North Fort Myers between former Lieutenant Governor Cocktown and his HOA. So he got that put in the bill. And there was a couple years ago with some of the collection amendments where you have to send out a notice when they're delinquent before you can attach attorney's fees. That has to do with a legislator that got into his fight with his condo board at the Tennyson in Tallahassee. I don't know what this means. I don't know what the intent of it means. I think the takeaway is if an owner asks for this accounting, one, it doesn't appear you can charge them for it. You can't charge for a estoppel certificate. And you have to tell them what they owe. It doesn't require you to tell them all the other criteria that's in estoppel certificates. I think you have to basically give them their ledger. And if there's fines, that needs to be shown on the ledger or somewhere or in a letter or somewhere else. So, there probably needs to be some administrative internal procedures on how to make sure you comply with this within the 15 days.
Mhm.
The consequences of not complying, or you can't collect those fines as they're stated. You want to comply with the statute. And I would just put together a form with, what their assessments are and what fines they owe if they pay.
Okay. All right. Any other questions on this one? All right, so Chuck, we're gonna put this one on associate to work on the administrative procedure in the form to be in compliance with this?
Yep.
Okay. All right. Okay. All right. Back to school. Directors now must attend a board certification course. In the past, a new director had the ability to sign a action form that says that they will adhere to the rules of the association. That is no longer possible. So newly elected directors must complete the class within 90 days, and the certificate is valid for up to 4 years. Every 4 years, a director must retake the course. Board certification course must include training related to financial literacy, transparency, record keeping, levying of fines, and notice and meeting requirements. Directors of fewer than 2,500 homes must also complete 4 hours of continuing education annually, while directors of more than 2,500 homes must complete 8 hours of continuing education annually. So the onus is on the board of directors to, on an annual basis, to get those four certified hours of continuing education. And we'll need to add this to Live Sandoval, a record of what courses each board member is certified for.
Hey, to the record, it was my understanding that incumbents are excluded from that provision, although I don't mind taking the 4 hours of continuing education. You recall that?
So, yeah, so I think the requirement to take the 4 hour initial new board member training only applies to newly elected directors. Then the statute is not well drafted on the additional 4 hours per year. So I think there's an argument that it only applies as new directors are brought on board. However, I agree with you. I think directors should comply with the 4 hour training and
On this law, that counts as one of those hours, does it not?
I don't know if the division has counted that or not.
Yeah, it did, but you had to,
Certification at the
you
end.
had to send something in to get the official
Yeah,
certificate.
I got a certification, yeah.
And the one that we
So
did,
we need 3 more, right?
Yeah.
the one we did on insurance too, that associate sponsored.
I don't believe that. I don't, the insurance one we did a few months back, I don't know if that had a certification to it or not.
I'm not sure. It will come with a certificate at the end.
Yeah.
Yeah.
It did. So, because it was prior to July 1, will it still count?
That's a good question.
Well, so was the other one. So was the other one.
It might count for the 4 hour continuing
Right.
ed. It wouldn't count for the initial.
Right,
Oh, sure,
right,
sure.
right, exactly.
And, the firm will be providing continuing ed,
Good.
both new board member and a regular continuing ed. And the division, the department, which is the department, the division of condominium timeshare and mobile home, which is part of DBPR, had to adopt rules for implementing these guidelines. They have not yet published those rules.
Okay.
So there is some open-endedness there on what exactly it's going to entail.
You're gonna make them available when Becker has it.
Yep.
Okay.
Thank you.
I'm actually doing, we're doing the 4 hour new hire, our new director training. We're breaking those up into 4 1 hour modules. I, along with one of my partners, recorded the module for, I think, budgets and reserves or something else. And they messed up the video and I have to do it again. So
Been there.
I digress.
Okay. Okay. Any other questions on this one before we move on? Okay. All right. Kickbacks are a 3rd-degree felony. What were they before?
Before, I don't think it was a criminal offense. It was shoot. You were subject to being removed.
Oh.
It was maybe a civil violation.
Okay.
Yeah, I mean, again,
this provision and a number of other provisions we talked about that seem kind of over the top are really in reaction to certain really bad examples out of the East Coast where you had these rogue HOAs that were committing crimes that were crimes. They were stealing the money and setting up fake contractors to pay fake contractors and like mafia stuff. What they were doing was a crime. The legislature didn't need to create new crimes. But here, you can't receive anything of value from someone who is providing services or offering to provide service to the association. That's now a third-degree felony. There are exceptions for food and trinkets and connection with trade shows or educational.
So for example, if one of our vendors gave the board members a coffee cup, would that be considered?
5 years in prison. I think it's a $5,000 fine. It doesn't have a de minimis, I mean, it's a fair question, but there's no de minimis value except for $25 per individual in connection with trade fairs or educational programs. So you can get a coffee cup or a koozie at the CAA trade show, or you can take a notepad from my office if you come in for an in-person training.
Right.
But if a vendor, drops off a box of donuts, you're going to jail for 5 years and you have a felony. You can't vote and you have to turn in your guns.
Okay. All right, moving on. The board, ARC, or similar committee must reasonably and equitably apply and enforce on all parcel owners the architectural standards found in the governing documents.
This was the law as I interpreted it without.
Yeah.
There's case law on selective enforcement and generally in the association context. So, I don't think this really changes anything. Maybe it will make bad behave ARCs be good behave ARCs. I don't think that really changes anything for Sandoval.
I don't think so. John.
A very good question about that one. Okay. Park denies an application. The resident brings the application to the board for an exception. The board grants an exception. Does that exception then become part of the law from that point on, or is it just an exception?
Well, my opinion, when you grant exceptions, you have to treat everybody that's similarly situated the same.
Okay.
So, exceptions swallow the rule. That's a good example where that's where that type of provision would come into play. But again, I think that was the law before.
Even if you change that in the standard, governing documents.
Well, if the rule changes,
Right.
it only applies prospectively. So if I'm going to make something up, but if the rule says you can have pink houses today and you change the color palette tomorrow, what that means is the next person who wants to paint their house pink can't, but you can't make me paint my house white. Okay. So it is the standards at the time the questions being considered, and you can change the standards on a prospective basis. But that doesn't mean you can go back and say, now someone has to change something that was previously allowed is no longer.
Okay. It's like case law. Yeah.
Okay, here we get into some interesting ones. The board, ARC, or similar committee may not enforce or adopt a covenant, rule, or guideline that limits or places requirements on the interior of a structure that is not visible from the parcel's frontage or an adjacent parcel, adjacent common areas, or community golf course. Second point, requires review and approval of plans and specifications for central air conditioning, refrigeration, heating, or ventilation system if the system is not visible from the parcel's frontage or an adjacent parcel, adjacent common area, or community golf course, and is substantially similar to a system that is approved or recommended by the association. So I am generally confused by this one because, especially in our community, even with some of our larger lot sizes, if you walk down the street, you can see most people's AC units.
Well, so it's important to remember what the first sentence says is you may not do these things.
Okay.
So you may not, the first one I don't think really applies to anybody. You can't regulate what people do on the interior if it's not visible from the exterior. So that one's pretty easy.
So that's the classic example of that is your blinds. If you have a white requirement on the back, that
Right.
can stay, correct, based on how you interpret this. Okay.
Okay.
That's probably the biggest one.
Yeah, the blinds are visible from the exterior. They're visible from the frontage and the adjacent part. Let's say blinds must be white or beige or whatever.
Okay. Thanks, Andrew.
The AC requirement, well, one, if you have a rule that just says you're allowed to have the ACs on the side of your house and they must be screened, assume that's similar to what your park.
We right now have it as landscaping requiring around it.
You have to have heading. That's fine, because that rule is not implicated by this, because those AC units are visible from the front or the adjacent parcel.
Okay.
This is, I guess if you had a parcel where the backyard is not visible from adjacent parcel or common area golf course, you can do whatever you can. It's again, it doesn't apply where it's visible.
So we have a limited number of parcels that back up to the fence of a public street or another community that the backyards are not visible from other neighbors.
Okay.
So in theory, it may apply to some of those houses.
Something like that. But for most communities where, you typically don't have, I don't know exactly, if you don't have fences between parcels, every parcel is visible from the adjacent part.
Well, in phase 3, the houses that are not on a lake back up to each other with a fence and landscaping that keeps privacy between the two lots.
So there, if it's not visible from, the frontage, adjacent parcel, the common area, they have, but again, you're not prohibiting people from having air conditioners.
Right.
So,
Right.
I guess to how this would apply to you, your rule says air conditioners have to be landscaped.
Right.
If they can put their air conditioner in the back of their house, they don't have to landscape it. If it's not visible from those other areas.
Okay.
So this would apply, it says it later on, but I'm gonna ask it now. Clotheslines.
We're going to get to that because I have that.
We're gonna get to that. We're gonna. Okay.
I'm prepped for that.
Okay. All right. So all right, Andrew, I'm gonna look to you. Do you think we need to do anything?
The ARC will review with rules assistance to make sure that our guidelines are clear on this. In a year and a half, or just over a year, I can't remember a time that we've commented on landscaping on the rear of a house. In most cases, if you're putting stuff within your screen lanais, we're not even making much of a comment on that. So,
Okay.
because we're deeming that to be inside your home.
Okay. Yeah. Okay. All right, the next one. Or before we move on, any other questions or comments on this one before we move on? Okay. Next one, if the association's board, ARC, or similar committee deny a parcel owner's request or application for the construction of a structure or other improvement on a parcel, the association must provide written notice to the owner stating within specificity the rule or covenant that was relied upon to deny the request/application and the specific aspect of the proposed improvement that does not conform with the rule or covenant. Do we have questions on this? Andrew, you want to comment on this at all?
We had already been doing that probably as of April.
Okay.
I took over the chairmanship role to ensure that was clear. As of the first set of denials that are going out this week from Saturday's meeting, we're providing to the homeowner the digital documents that deal with why we did it and what specifically is being denied for that reason, in order to give them guidance on how to correct their application and reapply.
All right. And
So, for instance, we had a house that wanted to be painted. the same color as its neighbor. We quoted architectural guideline 18 on page 11 that states every third house can be painted the same color. Okay, so to give an example of how specific we got,
Okay.
and provided the architectural guidelines to them in the email.
All right. And this is sort of an open question. I'm assuming that you're also working with associate for sort of like the administrative aspects of getting
Chris,
this out.
Chris
to them.
Harris gets that out for us. Yes.
Okay.
Let me rephrase that and not use a name. Compliance officer is helping us with that.
Do any other questions or comments on this before we move on? Okay.
Most cases, just as a course of normal business practice, the homeowner receives that denial. They're immediately coming to the ARC through our email, and we're beginning to work with them to improve and correct their applications. So it opens dialogue. Let's put it that way.
That's the right thing to do. That's
Okay.
best practice.
Thank you.
Yes.
Any other questions for Rob or Andrew on this one before we move on to clotheslines? It's okay. All right. Vegetable gardens and clotheslines have been specifically added to the non-exclusive exhaustive list of items that cannot be restricted if they cannot be seen. Clarification has been added added that the view is from the frontage, adjacent parcels, and now adjacent common areas or community golf courses.
Do you mind if I ask this? All right. So our bylaws and guidelines, or bylaws, let me be very clear. Bylaws as amended in 2014, let me get the exact date.
Yeah.
On July the 17th, so this month in 2014, 10 years ago. 8.4 specifically states along that lines, Rob, that was on the webinar, in my mind, that states whenever these bylaws refer to the Florida statutes, it shall be deemed to refer to the Florida statutes as they exist on the date these bylaws are recorded, except that amendments to Chapter 720 that are purely procedural in nature shall apply. We have a ban on clotheslines in our documents. We have a ban on
Vegetable gardens.
vegetable gardens. We have a ban on pickup trucks.
Fruit tree.
I was not aware till I was doing the reading on this. It's not just pickup trucks with commercial lettering, but all pickup trucks are noted to be in the garages. These are things that are within the bylaws and the declarations prior to this law. Does this law require us to change those
Well,
guidelines?
this law, one, only applies to those areas that are not visible from an adjacent parcel or a common area or community golf course or frontage or whatever.
Okay.
So I think you probably have even if this applies, if very few lot, it would apply to.
Okay.
That'd be one. What you're asking about is the retroactive application of substantive statutory amendments to existing documents, which is a somewhat complicated constitutional analysis of when the legislature can impair existing contract rights through subsequent statutory amendment. Your documents do not contain what is called Kaufman language. Kaufman language is referencing a condominium case, Kaufman v. Scheer, where the court found that when the declaration says the statute as amended from time to time was referenced in the declaration, their declaration of condominium, future amendments to the statute applied. But subsequent court cases have held where documents do not have that language, substantive amendments to the statute are not found to apply. You referenced the language in your bylaws that talks about referencing the Homeowners Association Act as of 2014 and only intending that subsequent procedural amendments apply, such as notice requirement. So, I don't think it's appropriate sitting here today to give the board opinion on whether or not these substantive statutory amendments do or do not apply. That is a question that is being, thoroughly reviewed by a number of associations, particularly with the truck parking question. It is going to get litigated, and someone is going to be the test case on that question. But if we want to further discuss that, I don't think this is the right forum.
I have a question about
Talk
procedure.
what provides.
So suppose the law contradicts one of our bylaws. In other words, supersedes one of our bylaws. Do we then go back and have to amend that bylaw, or just it stands due to the law?
On a procedural question, say it deals with notice. You don't have to amend the statute with control, but your bylaws say we anticipate incorporating procedural changes. So that just happens on the statute would apply.
But specifically, let's say the bylaws say that you can't have a vehicle with commercial signs on it.
Procedural days of notice for the meeting. That's a substantive change. So the question there is, can the legislature amend your documents or preempt your documents through legislative action when they do not contemplate incorporating future amendments?
So what are we doing?
So, Rob, you're suggesting that this is something we need to basically park for now and have further consultations with you on this.
Yeah. This one I don't have too much concern because I don't think it applies to any of the others. But the truck issue.
The truck issue, specifically when we get to that.
So,
That's a bylaw. Let's say it is a bylaw. The board can't change the bylaw. Bylaws can only be changed through the members.
right.
Right.
So for us to amend the bylaws, we would have to have a quorum, and then whatever majority of that quorum would have to approve that bylaw change.
Right.
Correct?
There's not a question of amending the bylaw. The question of whether the newly adopted statute preempts your documents, or whether your documents are not preempted by the statute.
As a contractual document. You
As a
can
contractual
even said that further,
Right.
using
Yes.
specifically
Well,
contractual.
This is the contract clause of the United States and Florida Constitution. The government cannot retroactively impair existing contract rights. Your governing documents, your declaration, your articles of incorporation, and your bylaws are a contract between the association and the owners. And the legislature generally cannot come in and change those rights through subsequently adopt. They apply prospectively, or they apply in very specific instances. One of those instances is when the documents specifically say, we, the parties to this contract, are going to live by the statutory amendments that the legislature may adopt. When your documents say, as amended from time to time. They do not. So that gets into the question of, is this the type of statutory change that can be applied retroactively? So what I'm saying is that's not a conversation we can have in this forum at this time.
Okay.
All right, so I think we will, when we get to that particular line item, we'll park that for probably a private board meeting, closed board meeting, and further discussion. Okay. All right. Thank you, Rob. Moving on. Enforcement hearings must be held within 90 days after issuance of the notice of hearing. The committee may hold a hearing by phone or other electronic means and provide this information to the individual so that they may participate by such means. So this is if I interpret this as a change to the covenants process. Any comments on that, Rob?
No, I mean, I think this is a good example of a procedural change. A lot of the other stuff we've been talking about is procedural change. This is requiring the timeline for having the hearing. I don't know that this really changes your practice. You just got to make sure you're following it.
Well, I know one thing that it changes. It's at least I think up to now we have asked people to appear in person for hearings.
I don't read this as mandating that you allow or I don't read this as mandating that you must allow electronic or remote participation. It's just that if you do, you got to give them the call in.
That may be helpful.
Yeah. Did,
I
sorry.
can't speak for covenants today,
right.
representing it last year. This would be helpful
Yes.
to some folks that have an issue getting there in person. So
Yeah.
yes.
That's again, the added language is the committee may hold the hearing by telephone or other electronic means. I don't read that as obligating the association, the committee to do that. However, I would agree with you. I think it's something the committee should consider to make, to make it easier and likelier that the owner can attend and will attend.
Right, because I think it that does two things. One is, we all have our personal lives, and if we need to attend a hearing, if we're not able to physically be present, let's say if we're working or if we're out of town, or if we're a snowbird, you still want to be able to have the ability to attend a hearing. Just because you're not in town doesn't mean you lose your right to do that. So we'll work with the covenants committee to get that procedure updated.
got Zoom accounts, that might be a
Well, we can get a dedicated Zoom account. It's $139 a year. I mean, it's
Yep.
relatively inexpensive to the community in general. Another procedural change: within 7 days after the hearing, the committee must provide notice of its decision. It must also include how the individual can fulfill a suspension or the date the fine must be paid by.
generally speaking, that's been our practice that once covenants has heard a hearing, it's releasing its decisions the next day with information on fineage and suspension.
Okay. We'll just have to ask the covenants committee to reinforce that formally
Yes.
that this is the practice.
That they are continue to practice as they have been.
Sure. Right, okay. Okay. Just collect my surveying here. Practice. Okay. If the violation is cured before the hearing or in the manner specified in the committee notice of hearing or the committee notice of decision, a fine or suspension may not be imposed.
That's a change.
Change to the process.
Yes. So now we would ask Chris prior to, or excuse me,
Compliance
compliance
officer.
officer prior to the hearing must confirm whether or not the issue has been resolved.
If it's of a nature that can be resolved,
Yes.
prior to hearing. This is what 72305 2B states, and this is not new language. This was actually changed, I think, last year or the year before. The notice, this is the notice of the hearing, must include a description of the alleged violation, the specific action required to cure such violation, if applicable, and the hearing date. So I read that as certain types of violations are curable. I need to mow my grass. I mow my grass. I've cured it. Certain types of violations are not curable. I broke a glass bottle on the pool deck. Like, I can't not break that glass bottle on the pool deck. That can't be cured. I had a loud party. That can't be cured. Parking violation. Whether unless it's like a ongoing type thing, it can't be cured. So I think you do have to recognize not every violation subject to that cure required. But if it is, you have to say, if it is, you did have to describe what you have to do to cure it. You must paint your house an approved color by this date. You must bring your lawn into, of course, you maintain a lawn, it's a bad example, but whatever.
Well, actually, about a third of the community is still on their own. Okay.
Maintain your yard, whatever, if it's the type of thing that can be cured, but certain one-off discrete actions can't be because they occur.
What we're running into, Rob, in most cases is they're receiving the notice that the board has approved fine. The hearing has been set 14 days or the third Thursday of every month. Oh, but I washed my roof in that period.
Okay.
Before we were sitting there going, well, you were given up to the board meeting.
Right.
Now
you have
that is considered cured.
Yeah.
Yes.
Okay.
That's a perfect example. In your room.
Yeah.
So, Andrew, you gave me some wording. The compliance officer must determine
if curable, to use Rob's language, curable violation has been corrected prior to the covenants hearing.
If curable violation. Prior to hearing. Okay, got it. Any other questions or comments on this one? Okay, next one. If the violation is not cured, the committee must set a date by which the fine must be paid, which date must be at least 30 days after delivery of the written notice of the committee's decision. Attorney's fees and cost may not be awarded against the owner based on actions taken by the board before the date set for the fine to be paid. Questions on this? Is this so this is no change to current procedure?
I'm not that deep into weeds on this one, so I would
Just
place
we-
this to ensure that the
Okay.
SOSHA and the compliance officer are ensuring that we're using this language in the covenants hearings decision.
Okay.
Makes sense?
Yes, I'm sorry, in the what? Written notice?
In the written notice of decision,
Okay,
that does directly impact the compliance officer's assistance with this.
okay,
And just to know, we currently are first notice 14 days, second notice 10, third notice 10. So we're at 34 days.
okay. Okay. Got it. Okay,
They have 30 days to pay their fine, it looks like.
okay. All right,
Did you read that correctly?
okay. Okay, we're in the home stretch.
That's change. Yeah, that's change. That's where that's the language it is.
Notwithstanding any provision to the contrary in the governing documents, an association may not levy a fine or impose a suspension for the following. Note, this specifically states fines and suspensions only. Leaving a garbage receptacle at the curb or end of the driveway within 24 hours before or after designated garbage collection day or time. My favorite is leaving holiday decorations or lights on a structure or other improvements on a parcel longer than indicated in the governing documents, unless the decorations or lights are left up for longer than 1 week after the association provides written notice of the violation to the owner. Questions on this? Rob, any comments on this?
Remember what I said about a legislator getting mad at their HOA?
Yeah. Yeah. So, okay.
I think our bylaw states specifically 6 weeks in advance of a holiday, you cannot put up decorations. You have till 30 days after the holiday to bring it down.
Okay. Oh. All decorations come down New Year's Day. No.
You go battle that one.
I'm joking. Okay. All right. That's a family yard.
Yeah,
Okay.
yeah.
All right. The following acts constitute a first degree misdemeanor. Does not apply to attorneys giving advice to clients. There you go. Knowing, aiding, abetting, or advising a person on the commission of a fraudulent voting activity in association election. Agreeing, conspiring, combining, or confederating with at least one other person to commit a fraudulent voting activity in an association election. Having knowledge of a fraudulent voting activity in an association election and given any aid to the offender with intent to help them avoid or escape detection, arrest, trial, or punishment.
But this job pays so well.
Yes, this is understood. Okay. Any questions on this one, guys? Okay. All right. Okay. Here we go. A prohibition against an owner, tenant, guest, or invitee of the owner from parking personal vehicles, including pickup trucks, in the owner's driveway or in any other area where an owner, tenant, guest, or invitee has a right to park as governed by state, county, and municipal regulations. The governing documents may not prohibit, regardless of any official insignia or visible designation, owner, tenant, guest, or invitee of the owner from parking their work vehicle which is not a commercial motor vehicle as defined in section 320-.01, section 25 in the owner's driveway. So this is getting into what we were talking about earlier, Rob, that this requires more discussion with the board.
Yeah, I would just point out, when it uses the term commercial vehicle and references 320, statute 320, commercial vehicles in that context are not what we think of in HOA context as commercial vehicles being vehicles with lettering. Statutory commercial vehicles are cement mixers. They are 3-axle vehicles that use, special diesel fuel, over 36,000 pounds, semi trucks, cement mixers, that sort of thing. So it's not referring to commercial vehicles in the context of vehicles with lettering or ladder racks or that sort of thing.
Okay. All right. Okay.
So we're saying we're gonna hold on that.
We're going to hold on that. This requires more discussion because there's,
We're gonna hear more
Yeah,
than anything.
so we're going to have probably a closed session to discuss this with Rob because we need to take some action on this. Or we can just wait for someone else to be first person up and deal with it.
well, does the discussion required privately include if a guest has a commercial vehicle, that it's okay for them to park on homeowner drive? Maybe that's part of the question that we need to have privately.
All right.
As a practical matter, can you cite one time in the last year where we've given a violation for this to anybody? No.
As a memory test, I
We
can't.
just want to know, that's,
Yeah, no, but
we may not have
if we
done.
don't do it, if we're not enforcing it, de facto, we're not enforcing it.
Right.
Yeah, it says it doesn't. We also have it in our.
You enforce it.
I don't.
Does that make sense?
Enforce a pickup truck.
Rob,
I don't worry.
Is enforce the pickup truck.
I'm right.
if we have a rule and are not enforcing it, does that negate the rule?
Problem. Yeah, I mean, if you're not enforcing, you create a collective enforcement problem.
Let's language rule
Yeah.
down because it's a bylaw. We're not enforcing a bylaw.
Another door.
Yeah.
Using rule colloquial.
Yeah.
Like document provision. There are ways to, like, setting aside the statutory issue that's out there are ways to cure that if you've historically not enforced a rule and now want to start enforcing it through the process to rehabilitate that rule. But kind of a different issue than the legislative amendment that we have to look at.
I think the question, John, that you're asking, what it comes down to is we haven't necessarily enforced it for pickup trucks without lettering. And there's been an agreed detente, we'll call it. But what happens when we start having commercial lettered vehicles that aren't classified as commercial vehicles? How are we going to deal with that?
Well, once our residents have seen this law and everybody's seen the newspaper, you're gonna see some of it.
Then we need to determine, to Rob's point, are we rehabilitating the bylaw at that point? If we can, that's the other question.
Right. We need, and as a board, we need to make some decisions because that would be not something that's a one-off issue. It would be, we have to have sort of like a sustained plan to deal with that. All right. So we'll have to do some more thinking about this and get together as part of a private board meeting and discuss some more detail.
The developers, and it's our number.
Okay.
It's number 13 vehicles. And the title of this specific document.
Can you talk a little bit louder, Andrew, so everybody can hear you?
Oh, I'm sorry. Yes, vehicles are number 13 in I believe it's the April 8th amendment to the declarations of the CCR, April 2008. No, sorry, Rob, let me get it.
2014 the latest.
It's the Sandoval amendment to the declaration on July 2005.
Pretty much, yeah.
It's Declarant B. It's Declarant B, the developers that developed the language.
Yeah.
And they corrected the original declaration to this one. Vehicles, it reads commercial vehicles or equipment, mobile homes, recreational vehicles, pickup trucks, ATVs, golf cart, three-wheelers, boats, and other watercraft trailers and stored vehicles may not be parked anywhere within the properties other than in enclosed garages, with the exceptions of law enforcement. Recreational vehicles and boats may be parked in driveways for no more than 24 hours for loading and unloading, twice a month. Standard pickup trucks of up to 3/4 of a ton capacity may be parked in the driveways, provided that A, they do not have any commercial signs or lettering. So it does allow pickup trucks.
Okay, so
They did clarify it there.
this commercial vehicle, let's not use commercial vehicle because it's used in the sense, this is lettered vehicle.
Lettered vehicles, yes.
Mm-hmm.
So they corrected it further down in the language,
All right.
Not in the condos. Yeah.
not in the condos.
That's correct. Yeah.
Condo just doesn't apply.
But they can't have suspensions that are altered, wheel tires. I mean, there's a bunch of what disqualifies the pickup truck.
Right.
So,
Yeah.
Okay.
but it's vehicle
Alright.
13.
Any other questions on this particular item? Okay. All right. A prohibition against owners from inviting, hiring, or allowing entry to a contractor or worker on the owner's parcel solely because the contractor is not a preferred vendor of the association. Additionally, governing documents may not preclude an owner from hiring a contractor solely because the contractor does not have a professional or occupational license. The association may not require a contractor to present or approve possession of a professional or occupational license to be allowed entry into the owner's parcel. So I'm going to start off with a question on this one. So right now, when we do an ARC application, we have to provide a certificate of insurance, workman's compensation, and Florida license, contractor license, for a contractor to be approved as part of an ARC application. Okay?
Can I preface it that as with the exception of that list of contractors that the state in its procuring process eliminated, Lee County and Cape Coral mirrored that. So example, a painter does not need to have a business license any longer. So they are not necessarily being issued a license, so we don't make that required.
Thank you for that, for clarification.
But a roofer, to Bill's point, still
Right.
does.
I would, to the, this is not in the ARC section of the statute.
Mm-hmm.
This is in the, do you let them through the gate section of the
Mhm.
statute? So you don't get to ask if the contractor who wants to come through the gate has a license or not, but that is irrelevant to the ARC issue. In my opinion. That's not where the legislature put it. This is not ARC approval.
Okay.
This is, you let them into the community so they can go to that lot.
Okay.
Okay.
All right. And
That may have not been the legislator's intent. It doesn't matter. What they
so
wrote
this
about.
does not change our qualification standards for a contractor to
Not
be
my
approved.
It's not in the ARC section.
Okay.
And we don't-
Questions?
And it's about entry.
And we don't typically have preferred vendors.
No, we don't have. I do know of an association does have preferred roofing vendors, but that's not here.
No.
Okay.
But even then, they typically don't not approve other people if they have the license insurance qualification.
Okay.
Okay.
But again, I read this as an entry issue, not an ARC issue.
Okay.
Okay. All right.
I'm sure it's a failure of appropriate drafting because they have demonstrated their intellectual prowess tonight, but it's not what it said.
Okay. All right. A prohibition regarding the operation of a vehicle that is not a commercial motor vehicle as defined in section 320.0125 in conformance with state traffic laws on public roads or right-of-ways or the owner's person. Yeah, what does that mean? Because right now we have a restriction against unlicensed golf carts on our streets.
Well, that I don't know that is operated in conformance with state law. So if you had a golf cart that was, low speed vehicle,
Right.
golf carts that are low speed vehicles means they have blinkers and seat belts and a license plate.
Right.
You could not prohibit them.
Right.
because they are allowed to be operated.
As long as they have a license and registration.
Yes.
But I don't know if this applies to you because this is talking about public roads or right of ways for the owner of the parcel. You do not have public roads or public right of ways. You have private road.
Okay.
It's gated. So this is not a section that applies to you. This applies to communities whose are not gated. So they have public roads that run through them, but they seek to regulate the activity on a public road. So you're not on a road.
Okay.
Okay.
All right. Yeah, there's a number of those types of communities. I know in Fort Myers area alone. Okay.
We actually have one road that we'd like them to take over as well.
Yeah. Public and the right of way or the owner.
Okay.
So you can't, you can't let them drive on their driveway. Yes.
Okay. Okay. Notwithstanding any provision in the declaration or bylaws does not state articles of incorporation, compound interest may not accrue on assessments and installments on assessments that are not paid when due. Okay.
No, I mean, the collection, Florida law already regulates collections and it's
Okay.
maximum rate of interest 18%, simple
Mhm.
interest. So,
Okay. All right. And the last one is the provision that allows law enforcement to park their vehicles regardless of any prohibition in the governing documents has been expanded to all first responders as defined in Florida section 112.1815, section 1, and now included public roads and right-of-way. First responder includes law enforcement, firefighters, emergency medical technician, or paramedic, or individuals volunteering in any of these roles. Questions on this one? Okay. Rob, you got any comments on this one?
No, I trying to see if your provision already exempted that. I thought no reason to.
It does, because we do allow law enforcement to park their vehicles. Like we have active law enforcement and
Yeah.
firefighters that park their vehicles in their driveways overnight or during their
Right.
when they're off shift.
So no, that would be really raising.
Yeah. All right. Okay. All right. Before we go to the last item, that I'd like to cover, is there any questions from any board member to go over any of these things that we've discussed? I know this has been a bit tedious, but I appreciate everybody's patience and
Well,
perseverance here.
I apologize. They revised it again in 09. Okay. So
I'll go through it.
yeah,
Okay. Yeah, thank you. So I'd like to
the
make
vehicle section.
that thing to pick up turns out.
Visibly
To comply with the American Disabilities Act.
at the pickup trucks.
So the Americans with Disabilities Act,
They don't have
parking apply to what are called places and public accommodations, hotels, restaurants, shopping center.
the pickup trucks.
Generally speaking, the clubhouse and amenities of a community association are not considered places of public accommodation unless they are made open to the public in some form. And there are areas, depending on what you do, there can be the potential that you are subject to the ADA if you allow outside events, things like that. Public is not people's guests. Residential guests are not public. Public is non-residential people.
But when we rent this room,
Okay.
you know, comply with the American Disabilities Act.
Well, do you rent it to outside people?
No, we only run it to residents.
So, but the ADA, complying with the ADA is like, do you have appropriate width doors? Do you have a handicap accessible bathroom?
Right.
Is it accessible? That's what the ADA is.
Okay.
What is generally applicable to community associations is the Fair Housing Act, the FHA. And there you are subject to the FHA. And while the ADA puts the burden on making the public accommodation accessible on the operator, The FHA, to the extent that modifications must be made, puts the burden on the person seeking the modification. So that's the difference. So typically, community associations that do not have a public-facing function are not subject to the ADA. You know, I have clients that are private communities, the golf courses, and they open the golf course up in the summer to public play. Well, you're subject to the ADA because you're allowing the public to come in. They host weddings. They allow the public to come in. If you don't do that and you only allow private internal functions, generally speaking, not an opinion you can rely on or hold against me in the future, you're not subject to the ADA.
Thank you.
Okay. All right. The last item I'd like to bring up before we conclude the meeting is I think it's important that we designate one board member to oversee the compliance or working on these tasks and then provide a monthly report to the board on the status of our compliance to these tasks. And to that end, I'd like to make a motion to nominate Beth Ann Holsey to be the representative on the board to oversee the compliance to these requirements. Do I have a second?
I'll gladly second that.
Great.
I think, yeah.
Do we have any discussion on this?
No, not if she.
All in favor? Are we ready to take a vote?
Yes.
All in favor, raise your hand and say aye.
Aye.
Aye. All opposed?
Thank you, Beth Ann.
No.
The motion carries. Congratulations, Beth Ann. Okay. So, on behalf of the association, Rob, I'd like to thank you. I think it's been very educational for all of us and for the community. This is being recorded on YouTube, so I think this is a good chance for us to go back and re-review it if we have some questions down the road to help ourselves. And with that, do I have a motion for adjournment?
I'll motion to adjourn.
Second. All in favor, say aye.
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 Resident comments?
Now, we are opening up resident comments. We purposely held this off to the end of the meeting so that it could be an interactive session. In the interest of time, I'd like to request that we try to keep each resident to 3 minutes each. So if any resident wants to come up and ask a question, please do so now.
I'm Debbie Ott, and I'm short. I think it was item number 10. They talked about how many days notice you needed to give an agenda for a meeting. And does that only count apply to the board meeting and not the various committee meetings?
I believe that just covers board meetings, but I think as a practice, we want to give as much reasonable notice as possible on committee meetings. And we need to make sure that they're public, that Life Sandoval has an accurate schedule of all the meetings.
Okay,
So
great.
I'm sorry.
To clarify that, with regard to committees, the law on committees is certain committees must function like the board. And those are committees that can make final ARC decisions. So your ARC committee has to function like the board, so they will have their notice 48 hours in advance on the website. Committees that can spend money, basically, are the other one that have to function like the board. Otherwise, committees are not subject to open meeting and notice requirements by law. The board can say, we want our committees to function subject to those two committees that are required to, like the board or in some way. So the board can impose that with law. So you need to set a policy.
Okay. All right. Thank you.
Would a standing schedule, Rob, a standing schedule that's drafted each month that states these are the ARC committee meeting dates, because I know that's the one that impacts the most. Does that count as enough announcement, or do we actually have it a separate notice?
The notice now
Available on our
agenda. It has to have the agenda. So I think it needs to be more specific than that. Say these are the 10 applications we're dealing with.
Sounds good. Fair enough.
Pretty safe.
And I did that for advance. Okay.
Okay.
That's good.
All right.
I'd like to get it back.
We're good.
Next speaker.
Okay, hi, I'm Denise Neifeld, Chair of the Communication Committee. I handle the website, I just had a couple questions on that. We have actually two websites, right? We have Times Square Associates and Life Sandoval. Do both websites have to be in compliance?
No, the associations designate Sandoval. I would say if you have another website through associate, fine. I would make sure that there is a clear, direction to go to, for Sandoval statutorily compliant website, click here or whatever. So there's a link to it. That would be.
Okay, we do have a link up already too. Is there any time frame to update the website?
So you have to be in compliance by January 1st, 2025.
Okay.
Time, but as we know it's now July. You blink and it's going to be October, and then it's Christmas. So,
Well, the good news is that we're very much in compliance with a lot of.
Now, just get it, across the finish line. I have clients who don't have sites that are going to have to do a lot of work in the coming months. So I think you guys are well ahead of the game.
What happens if it's not in compliance?
Well, it doesn't specify any specific punishment or consequence in the statute. However, it would be a statutory violation. Now, the Division of Condominium Timeshares and Mobile Homes has limited jurisdiction over homeowner associations. It does not have enforcement jurisdiction. So, theoretically, if you're not in compliance, I think an owner can file, some type of legal action against the association. And I guess potentially worst case outcome is they could get a court order directing you to comply and be awarded their attorney's fees.
Okay.
Yeah,
that does. I just wonder if there's any audit procedure that
no, because there's no state agency that oversees homeowner associations and that. The division has very limited jurisdiction over elections and recall homeowners associations, but it doesn't have general enforcement.
Okay, good. Thank you.
Thank you. Any other participants?
I'm here.
Tom?
You gotta know I'm gonna be here. I think it was in 10A, about 14 days, giving the agenda, and then something about 7 days, if there was something to be voted on, that information had to be given.
Membership meetings, or if there's a meeting to vote.
Not
on
a board
it.
meeting, just a membership meeting.
Right.
Okay.
So yeah, that is, if you have documents to be voted on, they have to be listed on the agenda at least 7 days before the meeting. But as a practical matter, that has to be all included in the 14-day mail notice, so you can post it all at once.
And number 19, you may want to look, you said it doesn't apply, but it's 1,000 parcels, so it applies, but it's something we were already doing.
This simply doesn't apply is the part of the statute that creates the audit requirement due to your revenue has always applied to you. So
But
this
so
is designed to capture associations who were not doing audits because they have more than 1,000 parcels, but a revenue of less than half.
If we have a contract that we sign, and in that contract, there's some sort of money given back to us in the contract that we sign, is that still okay? If it's giving back to the community?
Kickback, it's not
Okay.
to the board. Like
All right.
telecom contracts routinely have door fees.
Okay.
And
That's fine.
that's no.
And we do open our doors to like a flea market with that to the public, and we advertise. Does that put us with any concern about the ADA laws?
Talking about the
Garage sales.
garage sale. So they're but they're not invited. They're in first.
Well, garage sales to people's homes. A flea market occurs in this building. So this building then will be covered. Your home doesn't have to be covered, but that's the point.
I'm trying to remember what flea market are you talking about? I don't remember doing.
We have vendors come in here and sell their goods, and it's open to the public, not just this building.
The hasn't done the only events where we made venues since I've been here have been holiday events, for the residents to buy Christmas gifts or things like that.
And I can remember being outside, so just in case it comes up in the
Yeah.
future,
Okay.
if we have an event where we take the public in and they come into this building, are we supposed to be covered by the ADA laws?
Well, I'm gonna preface this by saying, when I get fair housing and ADA questions, I refer it to a partner of mine, and that's all they do.
Mhm.
So I'm not the expert on this. But if you're opening your doors to the public, that would seem to be creating a issue. And at least for that event, you may be subject to the accessibility requirements. So if your doors aren't wide enough, you don't have a handicap bathroom, you may have. But again, it goes to, do you actually have events that are open to the public?
So the answer is kind of yes.
Awesome.
Thank you.
Okay. Any other resident questions before we ask him? Tell everybody. Yes, sir.
I've got one, Bill. I'll just introduce myself. I'm Gary Keller, the board president for the Condo Association. Two things, I guess, from our standpoint, we try to mirror a lot of the stuff that Sandoval does. I don't know how much we're linked in to your website and how much of our documentation is tied into that. Being the new president, I guess I'd be kind of curious to find out how much of our stuff, if any of it is.
I can tell you right now, none of it is, because you go to the page for the condos.
Yep.
And it's basically what I would call a stub page.
Okay.
At least with the, in contrast to the villas, there is a significant amount of information regarding villas that are on the website.
All right. So we got a lot of work to do.
Yes. So if we want to do something, obviously we could look at some kind of sharing situation if that makes sense.
So for
Yes.
condominium,
Yeah.
You could add pages for the condo and put their governing documents on.
Okay.
That they have control over, so that it's their responsibility to maintain its accuracy and everything. Okay.
so for condominiums, there was a different bill that addressed some of the similar issues we talked about.
All right.
Regarding the website issue for condominium, the current law before July 1 of this year was condominiums that had 150 units or more had to have a website as of 4 or 5 years ago with similar requirements. They're reducing that down to, I think, 25 units. But your deadline's January 1st, 2026.
Okay.
So you have a year and a half to get that up to speed if you're now subject to that website requirement.
Yeah.
Very similar documents that we talked about, but the law is different.
Okay. The other one I'll throw in there is the pickup trucks.
None of that applies to you.
No.
That's all Chapter 720 stuff. They have not incorporated any of that language in Chapter
Because
718.
we are strict and always have been. And I have heard a lot of rumblings
Yeah.
of people chomping at the bit going,
For condominiums, if condominiums, that's totally different. The legislature did not change 718 with respect to pickup trucks. So
Okay.
you have a pickup truck prohibition in your documents.
Yep.
There's nothing in Chapter 718 that speaks to that.
all right, appreciate it. Thank you very
Absolutely.
much.
You're very welcome.
Thank you.
Thank you. Pleasure to meet you.
Pleasure.
Okay.
In reference to requirement for condominium website, they have Town Square, which is they're over 150, they're 174.
172.
Town Square itself actually houses the documents, it's pay cycle, minutes, all those things.
We do have a document that we'd like, that I would personally, I know Jeff Smith has worked on it, that we have an introduction for new people that buy into the condos, that we would love to be able to get into that link that is on your website, so that if somebody comes in, we would have that option.
Okay. All right. We can work through that.
Thank you. Thank you.
Okay. All right. Thank you. Any other resident questions, comments? Okay. Well, thank you everybody for sitting through this.
Bottom line, I have a close line.
Only if I can put up tomato plants.